Okay, hello and welcome everyone. My name is Jenna Pontius and I am the Public Services Librarian at the Riverside County Law Library. Welcome to our Book to Action and National Law Day Week program, Post-Conviction Relief Program. You have been muted and this session is being recorded, and I'm going to be monitoring the chat during the presentation, and we ask that you input your questions to the chat and then we're going to be answering them after the presentation. Our presenter today is Joshua Knight from the Riverside County Public Defender's Office, Writs and Appeals. Mr. Knight will be sharing about the Post-Conviction Relief Program offered by the Public Defender's Office. So thank you, Josh, for joining us, and I look forward to your presentation, and I will go ahead and share my screen.
Just start the slideshow. Good afternoon, everyone. My name is Josh Knight. I am the supervisor of the Writs and Appeals Division for the Law Office of the Public Defender, Riverside County. You can go to the next slide. I'm just going to kind of talk about, this chat is really about the post-conviction programs that we have once had and we're still working on somewhat. And then also the programs that we offer and are going to restart here in the middle of May. Just to kind of list the programs I'm going to be talking about. I mean, we used to do the 3 strikes reform petitions, Miller sentencing, and 1170D resentencings related to juvenile life without the possibility of parole sentences. Also, 1437 and 1170.95 proceedings. We still do writs of habeas corpus. Also, the programs that we do offer that the general public generally will reach out to us is regarding Proposition 47, Proposition 64, and our Fresh Start program. If you can go to the next slide. The one thing I wanted to tie in, because I know some of you have actually read the Just Mercy book. Hopefully you have all read it, but there's a discussion by Brian Stevenson about Miller versus Alabama. So I'm going to kind of jump to that first instead of the Proposition 36. Is that he talked about quite a bit. I think it's in chapter. I looked it up because I remember reading it as well. He talked about it in one of the last chapters. It's called Cruel and Unusual. And in my book, it's chapter 14. In my book, it's 263, but I don't know on the paperback if it's going to be there. But we did do, or I did handle a number of Miller resentencings that were initiated by writ of habeas corpus, and also that was when Miller was actually being argued in front of the U.S. Supreme Court. The California state legislature passed what's called SB 9, and that created something called 1170D2, which gave juveniles sentenced to life without parole another avenue to get resentencing. It was more based on rehabilitation, and so Miller was more of this sentencing decision, and 1170D was a resentencing decision. And Riverside County, I believe, had 25 juveniles that were sentenced to life without parole, and last time I looked, I think 12 of them still have that sentence. However, in the legislature a couple of years ago, I think it was two or 3 years ago, with Senate Bill 394, created a provision where all juveniles sentenced to life without parole would get a chance at parole after 25 actual years. And prior to that, with Miller, and I think that Mr. Stevenson talked about Graham as well, is that the legislature had created something called youthful offender parole proceedings, where a person is 25 or under, then gets a parole hearing after 15 years, 20 years, or 25 years, depending on their crime and sentence. And so we still do some proceedings for those that supplement to give the information about the person's youthful factors at the time of sentencing. But I put up Mr. Evan Miller's photograph to kind of give you a picture of him, because Mr. Stevenson doesn't have pictures in his book. but he was actually, you all may know that there was a recent decision dealing with Miller. It didn't repeal it, it didn't or overrule it. It just watered it down, is the way I would say it. And Mr. Miller was resentenced to life without parole, just I think on Tuesday, actually. Um, but that was his sentence, and it's, I can't say whether that's the final word. I imagine with Mr. Miller's case, it's not. We've also, I mean, I would say the criminal justice reforms really started with Proposition 36. Actually, two Proposition 36. There was one in the early 2000s for drug treatment, but Proposition 36 was written in tandem with the between the Stanford Three Strikes Project and the Los Angeles District Attorney, and they created reforms um, for the Three Strikes Law. And there was a lot of resentencings for people that had been sentenced to life, 25 to life. And so that was from 2012 until 2014. There was a lot of litigation in regards to that. And also, another thing that we were doing for quite a while, but we are not, are SB 1437s or 1170.95 petitions, which dealt with aider and abettor law changes as they applied to murder. So an aider and abettor who didn't have the intent to kill or wasn't the actual killer could get some resentencing and wouldn't be subject to the full punishment for murder if they were prosecuted under the felony murder rule or the natural and probable consequences doctrine. We still get appointments on habeases, but those are not initiated by us for the most part, but it generally deals with changes in the law. And I put down, there's Vargas, Chu, Chun, Rodriguez, Lee, McCart, Lopez. There's just been a lot of cases that have clarified existing law that applies retroactively. And so it depends. I mean, really, our workload regarding the habeas petitions depend on the new cases that the Supreme Court decides. If you could change to the next slide. The other programs that we do have is, and these are proposition driven, are Proposition 47 and Proposition 64. And Proposition 47 was passed, I believe, in 2014, and the petitions were supposed to be filed, I think, in 2018, but they've been extended because there have been so many petitions. But Proposition 47 permits some individuals to get their felonies reduced to a misdemeanor when they are possession of controlled substance charges, where it's simple possession for a person's own personal use, or for theft related offenses if the loss was less than $950. And this is something that can be, if you or a loved one are interested in this, you can call our office and inquire about whether this applies to a case that you have, because it's a filed. What would happen is a petition would be filed to determine if it was a simple drug possession charge, or if it was a theft charge of under $950. But Proposition 47 does have an exclusion, because if a person has actually been previously convicted of serious crimes or sex crimes, or have to register as a sex offender, they're not eligible for those petitions. You could change to the next slide. Proposition 64 was passed later, and I want to say it was 2016, but it permits people to have their felonies for marijuana possession or misdemeanors for marijuana possession reduced or dismissed. So it used to be that possession of marijuana for sales was a felony, and now it is a misdemeanor. And so a person, for most people, but for it could be reduced to a misdemeanor. But for simple possession charges or cultivation, some of those are dismissed entirely. So if you have a felony or a misdemeanor record for any of the following crimes, you can contact our office for assistance in in either reducing your felony to a misdemeanor or getting your felony dismissed entirely. Could you you could change to the next slide now too. One thing that, because COVID-19 has actually impacted our office, our resources, and really had kind of caused us to put some things on hold. And one of the things that we did put on hold during the shutdowns was our Fresh Start program. And our Fresh Start program is really to assist people who are seeking improved opportunities, be it employment, professional licensing, consumer credit, sometimes housing. That if they have a criminal record, there may be some form of a relief available for you. And so those convictions can be modified, they can be expunged, they can be reduced to a misdemeanor, where sometimes you can legally indicate that the charges could be dismissed, where you can indicate where you've not been convicted of crime. And then other times you can say that you're not convicted of a felony. And it really is Riverside County residents who have completed a prison term may be eligible for a certificate of rehabilitation. So I was going to go through just this is our aim really. We're going to be starting this up on May the 15th. We're going to start taking new cases and assisting people with this. If you can go to the next slide. So there's a number of things that we can assist with, and I tried to put it in the order of what people generally are asking us for. There's a dismissal or expungement. Those are the most common. There's also felony reductions. There's early termination of probations. That means a person is trying to get off probation earlier than expected. There's rehabilitations or pardons. There's also there's some that I'm not going to talk a lot in depth about, but there's modifications from a sentence, because it used to be that a person, if they were sentenced to a misdemeanor, they could get up to 365 days in jail. And that actually has immigration consequences. So the legislature passed a law to be able to modify it to 364 days. Also, there are sealing of juvenile records, sealing of arrest records, and there's even relief from 290 registration. All of these things are available, and you can inquire from our office to see if you can or would be able to get relief in these areas. If you could change to the next slide. Expungements are really our most common. This is a conviction can be set aside or dismissed on your record. So when you apply for most jobs, generally it doesn't apply to government jobs, you can legally indicate that you have not been convicted of that crime, that it was dismissed. In order to qualify for these, you have to be not on probation or parole and not been sentenced to state prison unless your case was served in county jail. There's now, with realignment, there's now state prison sentences that are served in county jail versus state prison. So if there was a state prison, 1170H is what we call it. But if there's a prison sentence served in county jail, there is a different vehicle to actually get it expunged. Also, you are not currently charged with a crime, and your conviction is from Riverside County. This and the specific code that allows you to withdraw. There's also another code to allow you to withdraw when you were on what's called a deferred entry of judgment program, or PC 1000. If you can change to the next one. Another thing that sometimes goes hand in hand with the expungements, but there are felony reductions, and this reduces a felony to a misdemeanor under Penal Code Section 17B. And you're eligible for this if your crime is what we call a wobbler. A wobbler is something that can be charged both as a felony or a misdemeanor. And so if you have one of these, and there's many wobblers. Well, just for an example, taking a vehicle without the owner's consent could be a felony and could be a misdemeanor. And so there is some benefits from trying to get this reduced from a felony to a misdemeanor. Especially sometimes people are actually advised when they enter a plea, if they fulfill certain requirements, then they would receive a misdemeanor. So if that was, in particular, if that was a part of your plea, you need to contact our office. Next slide, please. The other thing that comes up is early terminations of probation. And if you're still on probation and want your probation terminated, you can seek for it to be terminated early. But this is something you really have to have a good reason for to make a request. Sometimes you can have a job offer, and that job offer requires that you're not on probation. Or sometimes there's a plea agreement that says that you can get an early termination if you successfully complete certain terms. It's just really with an early termination of probation, you really need to explain why exactly you need to be off probation. Sometimes probation, a felony probation, will prevent you from being able to freely leave the state if you wanted to move and get a job offer. So all of those things you need to be able to really explain to us when you're applying for our services. Next slide, please. Finally, one of the more common things is that if a person goes to state prison, they cannot get their conviction expunged, but they may qualify for a certificate of rehabilitation. There are certain crimes that does not apply to, but in order to do this, you have to be a Riverside County resident for the past 5 years. It has to have been at least 7 years since your release of state prison, and you have to have not suffered any new convictions or received a violation of parole. Once a certificate of rehabilitation is granted, it's actually forwarded to the governor for review of whether a pardon should be entered. Next slide, please. So just to give you kind of an idea about our process, is that if you are looking for our services, you need to contact the public defender's office. And one of the first things that we would want from you is to fill out a financial declaration to see if you qualify for our services. But then if you do qualify for our services, we'll have you fill out your application and stating why and what type of relief you are seeking and why. And we're still, because of this is restarting, we're still talking about this, but we would want, I think we're going to want 3 to 5 kind of reference letters as well for just talking about your good character and your rehabilitation. And we will collect, after that, we'll collect all the information on you and evaluate how we can help. And we'll either agree to assist you and provide you a plan of what we will be able to assist you with, or we'll give you the resources to file on your own and kind of point you out, this is what you need to file, this is what you need to file. And so that is, I believe, all of that I wanted to say. Does anybody have any questions or comments? I will try to answer them. I can't see the chat box, by the way. Jenna, do you see any questions?
I'm looking now. There were no questions.
There are no questions.
And I can stop sharing so that it's easier to see the chat box.
Okay. And one of the things I would, I would recommend, I've always, there are oral arguments available. I think I was talking with Jenna about this earlier, is that there's a websites, I think OEA is the website. And then there's also, you can also watch on YouTube. Sometimes there's even oral arguments. And I would really recommend, if you're interested in watching the Miller versus Alabama argument on YouTube, because it has Brian Stevenson talking, and I found a version where a person actually was where the people arguing were dogs, because all we have is the recording. But you can when I just see a question from Victoria: how does one qualify financially to avail yourself to our services? This is something really that would have to be, there's a form that we would have to send you, and you have to fill out talking about how much money you make, how many dependents you have, whether you have any assets. And it's really a determination that's once you fill out the form, it's submitted to us, then we make the determination. Is there any other questions? Oh, and Jenna just sent the Oyas. I
Yes.
do recommend listening to it. It is very interesting. You can and one of the more interesting things is to listen to the back and forth between Justice Scalia and Mr. Stevenson. They are you can see they're all the justices are very smart people, and I found it very entertaining. But I'm a law guy.
I do have a question. So
Sure.
your Fresh Start program is restarting on May 15th.
Correct.
Will it be a combination of in-person and virtual, or complete one way or the other?
Generally, I think that we're going to try to do as much virtual as possible. You can certainly you can certainly contact or walk in, but I think that the forms that I'm trying to create readable PDFs so people can fill out the forms that give more information than trying to scribble it out. Because the forms are really important to fill out as much as possible, because we want to have as much information about why you're requesting the relief that you're requesting, because that is something that has to be communicated to the court. And so that's why when a person fills out the application and just tries to rush through it, we could be missing vital information that we need to convey to the court, or that the court needs to consider when determining whether to reduce your charge to a misdemeanor, terminate you off probation, or expunge your charge.
Thank you.
You're welcome.
So there's no other questions in the chat. I will take the opportunity to put some information. So like I said, this was part of our Book to Action National Law Day week, and we have 2 more events. Tomorrow, we are screening a documentary on Bryan Stevenson. It's from HBO, and it's called True Justice. And then our final event on Saturday for National Law Day, May 1st, we are having Obi Anthony from Exonerated Nation speak about his wrongful conviction, where he served 17 years in a California prison. And when he got out, he didn't have an ID card, he didn't have a resume, and he was able to then create a nonprofit organization called Exonerated Nation that now help people, exonerees like him, reacclimate to once they get out of prison, and reacclimate to society. And both of these events are free, and I will put the registration link in the chat. And then if you haven't already, Riverside County residents can sign up to get a free copy of the book, Just Mercy. I've put that link in the chat as well. And then you can pick it up from our downtown location or our Indio location. And then if there's any questions, I have our phone number.
Thank you very much, everyone, for coming.
Thank you so much, Josh, for telling us about this program. I found it really interesting, and thank you for tying it in with Just Mercy by talking about the Miller case. And it's really timely because they did just rule on, it just happened on Tuesday or Monday.
Well, I mean, there was a decision last weekend and there's a decision on Tuesday, so it really is timely. But this is something that I think that I foresee there being more litigation on this topic.
Yes. And then the recording will be made available to you afterwards. I'll send it out in an email. So if there are no other questions, someone said thank you to you and I, so you're welcome. Thank you all for joining us today. And I hope that you can use this information to either help yourself or someone that you know.
Take care, everybody.
Thank you.